Really looking forward to hearing our two speakers at tonight's forum. Just briefly in terms of the format. So we'll have our two speakers present first for around about 20 minutes each, and then we will have some time for question and answers following the presentations. But firstly, I'm delighted to introduce to you our first speaker for tonight, Tim Baxter. So Tim is the Senior Researcher for Climate Solutions at the Climate Council. Tim joined the Climate Council from the University of Melbourne, having taught and researched across a broad swathe of climate law and climate policy. Tim is also a passionate advocate for climate literacy and climate action. And like Elaine, he's also very active on Twitter. Welcome, Tim, and thank you very much for speaking to us this evening.
Thank you so much for having me. Now, I apologise in advance. At some stage this evening, I guarantee that one of my children will come in despite having been thoroughly briefed to stay the heck out. That will happen at a point in time. So I apologise that is going to happen, but it's the nature of the beast when you're doing evening talks and you have young-ish kids, not as young as they used to be. So yeah, as Kylie mentioned, I come from the University of Melbourne. Probably my unique qualification in talking about this, I'm not a lawyer, although I was a legal academic. I don't know when that stops happening. I think it's a bit like an infection. Eventually you get over it. But I spent a very long time looking at the prospects of one particular case in Australia and doing a lot of work with different groups and trying to sort of work out how to make that happen. And that was basically a case that I will talk about this evening, which is an Australian version of a particular Dutch case that happened a couple of years ago. I am just going to share my slides now. Now, if you just bear with me a second while I do that slightly awkward thing where I click around on different screens while looking a bit cross-eyed. Hey guys, I did say one of the kids would come in at some stage. Put them in quickly and then back up. Then get back out, please. Here we go. So there's that one, and then that one, and that should. Are you seeing my slides now?
Yes, we are.
Yep, or a few nodded heads, thank you. And so I come from the Climate Council, who most of you should be familiar with. I don't think I need to go through the background of that, but we're an NGO and a charity. And my role there is all sorts of things on climate solutions. So what I want you to take from tonight broadly, so we're talking about climate litigation and ways to use the law in Australia to do good on climate change. The law in Australia isn't particularly well adapted to doing this. It certainly wasn't designed to do this, and it isn't fit for purpose to make climate action happen. There's so much about the way that the law evolved that means that things like climate change are just problems that are in some ways, and I'm just going to pull this around here because I feel slightly awkward just looking at my slides. I'd like to have a friendly face somewhere on my screen. Climate change is a problem that in many ways is too big for the law to handle. That doesn't mean that the law can't handle it, or too big and too slow and too diffuse for the law to handle with traditional means. It doesn't mean that the law can't find ways to handle it. It's just that the existing set of tools that we have isn't necessarily well adapted. In a bad analogy perhaps is that the law is very much like having a bunch of tack hammers in your toolbox it deals with. Even though a lot of events are catastrophic in their impacts on an individual, they're not catastrophic in the way that climate change is catastrophic. You're talking about a fundamentally different thing. So even if, the law is reasonably well adapted to handle things like somebody died in a car accident and who is liable, and catastrophic, absolutely catastrophic. But when you compare that to the cumulative impact of climate change and the delay in the impact of climate change and the diffusion of responsibility for climate change, it really is a fundamentally very, very different beast. What that means is that really in order to make the law work for climate change and work in the interests of climate action, you really have to be a very creative thinker and thinking about issues in a very different kind of a way to how the law used to work. And there's quite a lot of there can be quite a lot of pushback from more conservative branches of the legal fraternity in this regard, because they like the law to do the things that it does and don't want necessarily to expand. That said, because there's this tension, it means that there are a huge set of possible options, possible ways to make the law work for climate action. And so we have, while the law is used to having, a tack hammer, we have a lot of different tack hammers. And while many of them, many of the individual cases or many of the individual suits that you could bring, particularly where we're talking about litigation, which is using the law through the courts for climate action, which is the focus of what I'm talking about tonight, rather than other ways to use the law. We have a lot of different tack hammers, and while they are all, generally speaking, most of them, if you look at them on paper, they're cases that have a very, very small chance of success. But anyone who knows statistics knows that if you have a 1 in 20 chance of success and you roll the die 50 times, you are going to have some big wins. And that's where climate litigation often is in Australia. Is the history of climate litigation in Australia is that there are these sort of Hail Mary pass type cases that are run. And a lot of them don't succeed, or at least they be able to say that they have an unmitigated success is really difficult. But then every so often you get these sorts of standout cases, and we had a clear example of that today. Parts of, I've been talking about this topic for some time, and parts of the case that came out today, which I'll talk about in a minute, Sharma and the Minister for the Environment, and this is not meant to be a pity me kind of thing, but having presented this information to more conservative lawyers in the past, I've been openly scoffed at for this being something that was possible. And, not that I'm going to get smug and childish and anything, but I sure showed that poopy, smelly bum, because today it turned out that you've got one of our justices of the federal court came out and basically said, without having ever read any of my stuff, or I don't know that he has read any of my stuff, without having read any of my stuff, saying, hey, Tim, you were right. And look, I'm not feeling like, emailing the judgment to some of the people who are more open in their derision. I'm not going to do that because I'm not that petty, but I'm certainly thinking about it and enjoying this moment a little bit, because this is the way the law tends to work, is you sort of, the way environmental lawyers work, and Elaine, I think, is probably a testament to this, is probably someone who's done this as much as anyone else, is you spend a lot of your time running at the wall and looking for weak spots in the wall. And you really are, it really is something where you run full pelt at the wall and bang, oh yeah, there's a wall there. Run full pelt at the wall, bang, there's a wall there. You do that a dozen times, and then one time you run at the wall, and suddenly you realize there actually wasn't a wall at the there at all, and you're on the other side, and you're like, oh shit, what do I do now? I'm in this whole new world, and that's the way legal evolutions work, is the really pushing often, particularly recently, people tending to be pushing for more creative solutions and things that certainly some people would say are unlikely to succeed. And of course they are, in many instances. A lot of these cases are on paper unlikely to succeed, but then some of them do. And the consequences of that, particularly with some of their more ambitious cases, can be radical. And I'll talk to that again in a second. So there are a bunch of different forms of climate litigation, and I'm going to talk about this in sort of a nerdy taxonomic way, a bit like species of animals here, of different ways that lawyers, different areas of law that you can use to do good on climate change. But just as evidence of that, the many ways to skin a cat that we have available. So flicking over. So in typologies of climate litigation, you have all of these different types that have been there. So in Australia, environmental law and in general, and climate law is par excellence, has been run largely under what's called administrative law. Now, administrative law is the legality of government decision making. Is it legally available for the government player to have made this decision in the way that they did without due regard to climate change? And there have been some successes in there, certainly, and there have been instances, and some of which Elaine herself has run, and this is where you're talking about, if the minister made this decision and they ignored the existence of an endangered species in the area, was that permissible at law when the act in question says that the government decision maker must consider this particular topic? And if the decision maker hasn't considered it, what's the consequence of that? Well, that, legally speaking, makes essentially negates that decision, means that decision has to be made, that decision is invalid and would have to be remade. And so, there have been a bunch of victories in this area. And some of the Adani cases are really good for this, where, the Environment Minister failed to consider certain endangered species. And as I understand it, and Elaine, you might know this better, as I understand it, the reason he failed to consider it is because the advisors in his department literally forgot to give him the report on the endangered species when he was making the decision, which is, that is egregious. Someone forgot to put a staple in and forgot to give it to him, but the report existed and he just didn't consider it before he approved it. He took some of the reports home, took 90% of the reports home, made his decision, and the court said, well, you didn't consider it, so therefore your decision is void. And that's great, that's fantastic, except that what is then completely available to the minister is to go back to his department and say, you idiots, you forgot to give me all of those reports. Give me all of those reports now, and I'm going to go and make the exact same decision. And so that's sort of downplaying the impact of this area of law, because it plays a really key role in frustrating negative developments. And so, the Adani mine, while getting close to development, certainly hasn't been developed yet. And it has a big impact on the economics, and it has the big impact on the entire momentum of the project, and that frustration eventually can be total. But it plays part. But it also plays a part in a key movement, in a key, with other campaigns and other ways of dealing with this that are extraneous to the litigation process. You have human rights cases. Human rights cases don't happen often in Australia, partly because in most places, we don't really have strong human rights law. We don't have Commonwealth Bill of Human Rights. So there is no right to life in Australia. There is not really. There is any number of other rights that are appreciated and valued, even negative ones, like in the US, the right to bear arms. Those don't exist in Australia. We have the implied right of freedom of political communication, and that's basically it, which is not a lot. It's been used for a lot of great effects, but that's basically all we have in Australia. That said, there's a new trend of cases that are using a couple of the states now have human rights bills. So Victoria and Queensland in particular, and ACT as well, have human rights bills. And there's some moves most recently, particularly with the Queensland Human Rights Act, to start seeing if can we use these for the law. Our Human Rights Acts aren't written in the way that they are overseas, though. It's just another act of parliament. It's not something that it reigns supreme over everything like the US Constitution does. So this is all very unfamiliar territory, and it's a creative way of thinking about the problem, is to say, can we use this thing for this purpose? And it's really unclear whether that will work. Not saying that it's not a strong idea and something worth exploring, but it's unclear. We also have tort claims. Now, law of tort, it's a funny word, sounds like a cake. I was a tort teacher, and it was always funny to be the person who taught torts. Torts is the law of negligence and the law of personal claims between people. So if you crash your car into someone else's car, the thing that means that you have to pay is the law of tort, the laws of negligence and the laws of nuisance and the rights between individuals. Oops, that wasn't supposed to happen yet. Tort is historically has been pretty rarely used against government actions, but there's people who are starting to think of ways to use the law of tort against government actions or other forms of climate litigation. Some regional governments in the United States are trying to use it to sue the carbon majors, the laws of nuisance, and saying your emissions created a nuisance that negatively affected our value and enjoyment of land. Yeah, this is a really developing area of law, and one of the most spectacular victories in climate litigation history is the Dutch case of Ahender in the Netherlands, where an NGO over there successfully sued the Dutch government because their climate targets were insufficient to face up to the problem of climate change. And they had an absolutely spectacular victory. They, as with all of their cases, and this is one was, again, par excellence, was everyone told them that it couldn't work and the law of tort couldn't do what they said they should do because it is a small tackhammer dealing with a very, very big problem. It's an area of law that was designed for, land disputes and individual backwards and forwards disputes. The first big negligence case worldwide was somebody who was suing a ginger beer company because they found a half a decomposed snail in their bottle of ginger beer and got sick from it. So, awful, but small scale. To then try and use that law to fix a problem like climate change is just the issues of scale there are remarkable. And, everyone said, absolutely not going to win. It's not even a point running it. And you've got a bunch of academic articles from the Netherlands saying exactly this. And it's like, wow, you guys sure got egg on your face. Because not only did they win a unanimous victory at the Hague District Court, so not people say, going to the Hague is just a town, the District Court of the Hague. They got a unanimous victory at the District Court. And the government appealed the decision because obviously they didn't like the finding that their climate targets were negligent and that they had to improve them. So they appealed that to the intermediate court, which is called the Supreme Court in the Netherlands, Court of Appeal in the Netherlands, and they gave a unanimous verdict for the people who are the NGO again. So that's two unanimous verdicts. And not only that, they said, oh, actually, they kind of, the first court erred, but it erred because it dismissed this extra bit of the law. So the government appealed and it absolutely blew back on them because it doubled the amount of legal authority for the case. And then the Dutch government appealed again to the highest court in the land in the Netherlands, their equivalent of the High Court, and again got a unanimous verdict, which is just this remarkable series of victories. And my research was very much about, is a case like that applicable in Australia? Could that be done in Australia? And in many ways, our law of negligence, while you can't take, especially across a divide like the laws of Europe and the laws of Australia, you can't take direct analogues. Precedent, in the way that they talk about it, doesn't work across that boundary because it's an entirely different legal system. We do have English laws in our legal system, English cases that are considered in our legal system, but that's because we're similar. The Dutch law is not similar at all. And I was looking at whether that could work for Australia. And my theory is it's possible, as I've been saying with this kind of stuff. It's unlikely, but it's possible. And today we had the decision in Sharma and Minister for the Environment, where 8 teenagers represented by an adult sued the Minister for the Environment for her failure to consider her duty of care, her duty of responsibility. Same thing that applies when you crash your car into someone else's car. You have a duty of care, which is the foundation of the problem. Whether the minister had a duty to consider the impact of this new coal mine or the coal mine expansion on future generations. And it was found that she absolutely did. Now, there wasn't a successful, they didn't successfully argue the ability to get a remedy. So the teenagers were asking for the court to prevent the minister from from approving the mine. The judge didn't make that decision in this particular instance partly for a bunch of complicated legal reasons, but this is set, and it's a remarkable win in the long term, because we just basically now, as legal academics, someone just has to find the right set of facts, and this case can be run and won, and that's where it's at the moment. So we are really very much through the looking glass today, which is part of the reason that Elaine and I spent a long time today reading this 100+ page judgment, trying to find what the next step is. It doesn't mean that it's inevitable to win, but it's winnable, and then far more winnable than it was, 24 hours ago. And again, feeling a bit smug because called it. We then have public trust, which doesn't really exist in Australia properly, but there's this idea of responsibility of the government to manage what is generally the commons, those common areas of common benefit and common responsibility, in a way that benefits future generations. And so one of the big ones they talk about is the atmospheric trust, which is your basically leaving the atmosphere in a state that is usable for the future and not derogating from that. In the same way as you would think about it for an investment, someone who's running an investment portfolio, you needs to manage it in a way that's not going to degrade the quality of that portfolio. It's kind of similar. We don't really have that in Australia, but there's been a bunch of attempts to see if we can use that for climate change. So find out basically if there is an atmospheric trust, and how that works. You have constitutional law. Now, constitutional law in Australia is not usually very good for these types of problems, but we do have some instances of it being used really well overseas. So in New Zealand, there were some Māori groups who were trying to use it under the Waitangi Treaty. There are some conditions in the Waitangi Treaty that require the New South Wales government to take active protection of natural resources. And so that was attempted to be used for climate purposes. We have statutory claims. So a lot of laws on the paper have various bits and pieces that say, a person, whatever, and a ... must, whatever. And there are a whole set of those. Basically every act binds somebody to do something. So there are a bunch of ways that people are looking at all these various bits and pieces to see if they can find what that something is. I recognize that I'm running out of time, so you might notice that I'm speeding up, which is intentional. We have directors' duties of companies. There's a bunch of really interesting work. So directors have a responsibility to manage their companies with care and diligence, for the rights of shareholders. Now, this is usually considered to be the rights of them to receive rights of shareholders to receive a financial benefit from their investment in the company, but there's a lot of work done to sort of work out what that means in the context of climate change. Because if you're a company director who's not managing for this very real future impact of climate change, then you're not managing that financial benefit responsibly. Also, we've already had first rounds of preliminary litigation happening in Australia through the Mackay case, where a young man tried to sue his superannuation company for failure to manage the investments appropriately with regard to climate risk. A bunch of laws with regard to people's access to information. So this in Australia would be the freedom of information stuff. In the European Union, there's a lot of stuff around this because they have conventions about what information the government must provide its citizens related to climate change. That means people are taking various cases on that to learn more and more about what's happening and get access to stuff. There's been a few cases of that. There's even migration cases. So we've had our first instances of people attempting to find a right as a climate litigation. So a man from Kiribati tried to sue the New Zealand government for refugee status as a result of the future climate impact that is going to be happening in the islands. Wasn't successful in that instance, but it is an area for active growth, I guess. Now I am very much behind. We have here a bunch of these things where I was talking about the creative solutions. These are the ones that I would say are probably more out of the box, more, I can never remember whether left-brained and right-brained is out of the box, but whichever one is that. These are the ones that are, there's something that a former colleague of mine used to describe as the next wave of climate litigation, this next frontier that we have. I am going to skip through this one broadly. but I'll send my slides through so you can have a look at what's in here. And that's just because I'm running way behind time. Sorry, I didn't see the clock. Classic me. What we have in Australia is a bunch of judgments that are basically reading down climate impact over time. You can have a look at these in your own time. There's nothing particularly that I need to talk through with you, but it is, courts have traditionally been very, very narrow in the way that they consider what climate change is. That is starting to open up and has opened up a lot as of today. And I've got on here, but see Rocky Hill, because Elaine's going to talk to that in a second. In conclusion, yes, and I am absolutely editorializing here, the legal system will shift eventually on climate change and these bigger environmental threats eventually, but it will take time and a lot of creative thinking, something that we don't necessarily have a lot of now. But there is a dam that has been broken recently with regard to climate litigation, in the sense that the ratio of strong victories to strong failures is shifting quite dramatically and over quite a short period of time. There are many threads to a broader legal strategy, and some will fail, but it is never too late to improve our relationship to the environment through the law, even if it is urgent. So it is absolutely urgent, and as a representative of the Climate Council, we know urgent, but it is a tool that we have that is available, and it will improve over time. I'm going to hand over to Elaine. Sorry for running a bit over. Should have stopped sharing now.
Thank you very much, Tim. That was great. Can everyone hear me? Yes, fantastic. Okay, look, thank you. Really appreciate the presentation. As I said, we will leave our question and answer session to the end. So all sorts of ideas and questions starting to come in. Please do include any comments and questions that you have in the chat. But next I'd like to move on, and I'm delighted to introduce to you Elaine Johnson as our second speaker this evening. So Elaine is a solicitor and the Director of Legal Strategy at the National Environmental Defenders Office. Elaine joined the EDO in 2011 as a solicitor in their Sydney office and is speaking to us from Sydney this evening. She provides clients with advice and representation on a wide range of environmental legal issues, including civil enforcement, administrative law, planning, pollution, biodiversity, mining, and coal seam gas. And just a couple of references to some of Elaine's successful legal work in the climate space. Elaine was a solicitor on record in the landmark Rocky Hill coal mine litigation, which resulted in refusal of the greenfield mine and changed the legal landscape on climate law in Australia. She's also acting for bushfire survivors in groundbreaking climate litigation against the New South Wales Environment Protection Authority. Elaine also represented the Mackay Conservation Group in successfully overturning federal approval of Australia's largest coal mine, the Carmichael mine in the Galilee Basin. Thank you, Elaine. Over to you.
Thanks so much, Kylie. And some of those cases there are some of them that Tim's sort of touched on in his presentation. So I'll just share my screen with you now. And can you see that? So I'm just going to talk through briefly some of the cases that the EDO has run recently and currently has in court, using some of those legal mechanisms that Tim's run you through in his typology, which was very helpful, Tim. I should have been taking notes. And then there's so much happening in this space at the moment, as Tim has mentioned, in particular this week. And Tim's touched on the Sharma case that was handed down this morning from the federal court that we're all extremely excited about. And I thought I would just briefly touch on another important case that was handed down overnight in Europe relating to the Royal Dutch Shell Company. So before I do that, I might just talk to you a little bit about the EDO generally. And see if I can get my slides to move. So what's the Environmental Defenders Office? We're an environmental law practice that protects the environment in the Australia Pacific region, and we do that through a number of different ways. We work with our clients and communities to deliver innovative legal solutions and we empower communities to fight for nature through the law. We educate people about the law and their legal rights in relation to issues like climate change, biodiversity, and other environmental matters. We advocate for better laws that deliver transformative change, and we litigate to uphold rights and enforce the law. So it's that last element that I'm going to talk to you tonight about. So within the National EDO, we have 4 programs of work. I'm the Director of Legal Strategy, so I lead the Systemic Change program at the EDO. We have a Healthy Environment and Justice program, which works with managing lawyers across the country in each jurisdiction around Australia, except Victoria. We don't yet have an office in Victoria, but hopefully we'll one day in the not too distant future. And that continues our ongoing work with communities on the ground on environmental issues. We have a First Nations and Indigenous Peoples program that we're in the process of developing through a consultancy. And we have a science and expert advisory program, and that program is really critical to all of the work we do. We have a couple of in-house scientists who work with us on all our case development and advice that we give to clients across the country. And without that expert advice in-house, we just simply couldn't do the work that we do. And of course, through that advisory program, we work with a whole range of independent experts, scientific experts across the country. And Tim would be aware that we work with some of the wonderful scientists at the Climate Council as well, who help us out with litigation and casework. So the goal of the Systemic Change program that I lead is to bring about systemic legal change that protects nature and our climate through leadership, partnerships, and transformative legal strategies across our 4 focus areas, which are safe climate, protection of biodiversity, ensuring freshwater protection, and our international program, which works with our partners in the Pacific Islands on all of those issues. Within our Safe Climate program, our 4 main focus areas are on coal and gas, which are our 2 sort of primary exports in Australia that constitute the majority of Australia's contribution to global emissions. And we also are focused on using human rights law to tackle climate issues. And we've also just recently developed a corporate and commercial arm to our Safe Climate program to look at holding companies to account. And we work on these issues through providing access to the courts, through litigation, through law reform and policy work at a national and state level, and providing legal education to communities and the profession around climate change. So I wanted to talk about a couple of our cases tonight. One of the recent cases that we had success on in the climate space is the Rocky Hill case that Tim mentioned in his presentation. This was an appeal to the Land and Environment Court in New South Wales, which had been brought by a company called Gloucester Resources. That company wanted to build an open-cut greenfield coal mine in the Gloucester Valley, and you can see up the top there, I've got a picture of Gloucester, and it's just this absolutely beautiful scenic valley, which is lush and green, hosts, you know, a range of different agricultural activities, and is also a really popular tourist destination. So our clients were the Groundswell Gloucester Group, and I've got their name around the wrong way. It's not Gloucester Groundswell, it's Groundswell Gloucester. And they represented a whole range of people within the Gloucester community who were concerned about the impacts of the coal mine, not just on their beautiful valley, but also the impact that it would have on the global climate and future generations. So our client approached us when they found out that Gloucester Resources was appealing an initial refusal of the coal mine to the Land and Environment Court, and asked for advice as to whether they could apply to the court to join that case to raise the issues that were really important to them, to advocate for refusal of the coal mine by the court. So we agreed to do that, and we approached the court on an application for joinder. And in that application, we had to demonstrate to the court that the community in Gloucester had a right to be heard in the company's application for approval of its coal mine before the court. Much like Tim was talking about earlier, this case was filed in 2018 at a time when there was absolutely no guarantee that the community would even be allowed to raise the issue of climate change in connection with an application by a private company for the building of an open cut coal mine. And that hearing that we had to apply to join our clients to the case demonstrated some of what Tim was talking about earlier, where the defence from the mine against that application to even be heard in the case was put down with the sorts of submissions that said that our clients were attempting to raise a global geopolitical issue in a local context, and it was simply not an appropriate forum to have a discussion about climate change and global emissions on an application by a private mining company to open up a new coal mine. So against all odds at the time, our client was successful in being joined to that case and was allowed to raise the issue of climate change in connection with this coal mine application. And happily, following the hearing, a 3-week trial in which a whole range of expert evidence was put forward on the issue of climate change, including by the wonderful Professor Will Steffen, who Tim no doubt knows well from the Climate Council, on the impact of opening up this new greenfield coal mine on our global climate. Ultimately, we were successful on behalf of the community in obtaining a refusal by the court for this mine, including on the grounds that the mine would contribute to global emissions, and that would have dire consequences for the community in New South Wales. So it really was, we're calling it a landmark judgment because it really was the first time in Australia that a court had made that really clear link between the opening up of new fossil fuel reserves, the impact that those emissions arising from the burning of that coal overseas would have on the global climate, and linking it back to climate impacts for communities here locally in New South Wales. And I just wanted to read to you part of the judgment from the Chief Judge, Justice Preston, in that case, because this was really quite a significant moment in climate litigation, just as today is another significant moment in the progression of climate law in Australia. The Chief Judge in this case said, in short, an open cut coal mine in this part of the Gloucester Valley would be in the wrong place at the wrong time. The wrong place because an open cut coal mine in this scenic and cultural landscape proximate to many people's houses and farms will cause significant planning, amenity, visual and social impacts. Wrong time because the greenhouse gas emissions of the coal mine and its coal product would increase global total concentrations of GHGs at a time when what is now urgently needed in order to meet generally agreed climate targets is a rapid and decrease in GHG emissions. And the Chief Judge concluded these dire consequences should be avoided. The project should be refused. And that was the final paragraph of a 700-paragraph judgment in which the Chief Judge had carefully gone through each element of the evidence that had been put to the court during the hearing, including all of that wonderful evidence that was put on by the experts that gave evidence for the community on climate harm. And so just briefly, 2 other cases that we've currently got in court that are raising climate change as issues for communities. The first one is the bushfire survivors case. So we're acting for the bushfire survivors for climate action, and they're bringing a case against the Environment Protection Authority in New South Wales. This case is being listed for hearing in August this year. The basis of the case that's been brought by our clients is that the EPA owes a duty, a statutory duty under its enabling legislation to prepare objectives, guidelines and policies to ensure environmental protection, and that duty can't reasonably be fulfilled without the EPA adequately addressing climate change and the reduction of emissions in line with the Paris goals of achieving global temperature rise of no more than 1.5 degrees Celsius. So that case is yet to be heard, and so watch this space. And we wouldn't want to preempt anything that the court might decide in that litigation, but it's certainly, you know, it's an interesting case, I think, that draws on some of those novel aspects of the law that Tim had highlighted in his presentation around statutory duties and torts-based climate litigation. So we will no doubt keep everyone informed as that case progresses. And finally, in terms of some of the EDO litigation I wanted to talk about today, and this by no means encapsulates all our climate cases, but just some of them that I think are interesting to watch at the moment. We're also running a piece of litigation in the Queensland Land Court, which uses, it's the first human rights-based climate case to be brought in Australia, and it looks at the Queensland Human Rights Act, which came into force very recently. Now, this is a case where we're acting for two clients. One is a group called Youth Verdict, and that's a group of young Australians. And the second client we're acting for is the Bimblebox Alliance, and they're a community group that owns land and property in the vicinity of Clive Palmer's proposed Galilee coal project in Queensland. So those two clients the EDO is acting for are bringing an objection to this proposed new a massive coal project in Queensland that Clive Palmer wants to build in the Galilee Basin. And the really novel and interesting thing about this case is that our clients are raising climate change as not just an environmental issue, but also as a human rights issue. And they say that when they look to the Queensland Human Rights Act, that the approval of this mine would be in breach of human rights that apply to young people, including their right to life and culture, and putting land, lives and livelihoods at greater risk. So this, again, I think is another one of those cases that's a bit out of the box in the Australian context, because we haven't seen yet a human rights-based climate case. While we don't have national human rights legislation, there are opportunities to look at state-based human rights legislation, particularly as we get the jurisprudence, meaning lots of other cases around the world are bringing human rights and climate change together. And we hope that, you know, this will be one of many climate cases that looks to human rights. And just finally, so this was a decision that came down last night, and this was another really significant win in the climate space. It's a case brought by 7 plaintiffs led by Friends of the Earth in the Netherlands against Royal Dutch Shell Company. And in this case, it's the first case that we know of where a carbon major has been held liable for causing dangerous climate change. There's many cases around the world, including quite a significant body of case law in the United States that seeks to hold carbon majors liable for climate harm. Those cases are still on foot, but this is really a significant judgment that's come out of the Netherlands last night, where the court found that Shell was, that Shell did owe a duty of care in relation to its emissions globally. The case was brought under the Dutch Civil Code and the relevant duty of care provisions there, as well as connected with European and international human rights conventions. And it also brought in what we call soft law. So to help to apply those human rights conventions and the Dutch Civil Code to a company like Shell, the court has brought in soft law that applies to corporations, like the OECD guidelines for multinational corporations, and there's a number of other forms of soft law that it's used to apply those sorts of rights and duties to a company. So some of the key findings that came out of this case last night included that the court has ordered that Shell must reduce its emissions by 45% net by the end of 2030. It's found also that Shell is responsible for emissions from customers and suppliers, which we call Scope 3 emissions. The court found that there is a threat of human rights violations by the emissions caused by Shell to the right to life and undisturbed family life rights. And finally, that Shell must comply with the judgment immediately, as its current climate policy is not concrete enough to meet that, that reduction obligation that the court found that Shell has. So this is another really significant victory out of the Netherlands, and there's a lot of climate lawyers around the world also very excited about this case too, and thinking about how it might apply to other fossil fuel companies and carbon majors that are responsible for climate harm. So that's it from me. If you want some advice about your legal rights, then please do get in touch with us. We have a national intake service for legal advice. We also have a range of fact sheets and resources on our website, and you're very welcome to sign up to our legal updates bulletin to hear more about all the cases that the EDO is running. And of course, if you want to support our work, you can visit our website and find out how to donate and become a partner with EDO in the work we do. So thanks very much, Kylie.
Thank you very much, Elaine. That was fantastic. I think we're probably going to run out of Q&A time pretty quickly too, actually. So many questions coming and things coming to mind for both yourself and Tim. Thank you both for those fabulous presentations. Now, our first question this evening, thank you to everyone for putting your questions into the chat, and continue to put comments and questions in as we go through now. Either of Tim or Elaine, could the decision to spend $600 million on the Kurri Kurri gas plant, which has been in the media quite a bit, particularly following the budget in recent weeks, be the subject of a negligence claim against the Australian government? Any thoughts?
So I'm going to preface this by saying I am not a lawyer, so nothing I say is legal advice. Don't follow what I say. I'm a former legal academic, and if I give legal advice, that gets me in really hot water really, really fast. In principle, ordinarily you would need to have some kind of affirmative, really solid decision to appeal against. Now, I say in principle, especially because today's decision, one of the big reasons that it fell over was because there hadn't already been an environmental approval of the coal mine expansion. This is the Sharma and Minister for Environment case that happened this very first thing this morning. You would ideally, for a case like this, you would want to be very close to a decision point. With the Kurri Kurri gas plant, it at this stage is just an announcement. There's an environmental impact statement on the New South Wales Department website. By the way, we strongly encourage everyone to submit to that if you have some spare time and just say, what on earth are you doing? This makes no earthly sense whatsoever, which is another way to engage with the law and this process. Yeah, I don't know, Elaine, if you have different thoughts to that.
Yes, I think that, you know, with this decision that's come out today, it's very much watch this space on what happens next. I think that all of us are reading it very closely and working out how and when it might apply in other situations and circumstances. So I think it's probably too early to say what the effect of the decision might be on something like the curry plant proposal. But yeah, certainly there's lots of eyes on this decision and where it might apply next.
Absolutely. Look, a couple of other things. Tourism industry, and whether this be people enjoying national parks where they might be being logged. So deforestation is a key concern of many of our members and obviously beyond. And we had a recent forum focusing on that. And also even thinking about tourism operators, for example, in the Great Barrier Reef, what is the potential for operators within the industry, whether it's as some sort of a coalition, to take legal action against the government for a lack of action on climate change?
I'm only going to jump in first. I was intending to go backwards and forwards for Elaine first talking first, but I'm only going to talk first on this one because I've literally written an article on specifically this, which I'll drop in the chat. Again, it's quite possible. I actually think that's for a negligence claim in Australia. I think that's one of the strongest. Again, it's still hypothetical. Like I notice there's a lot of questions about what about this person? What about this person? What about this person? Can they sue? In a lot of instances, the question is, it's possible, but we don't know how strong the case is. A lot of the answers you'll find from us will be the same. It's like you don't know until you get there, and so it's a matter of, particularly for a litigator, someone who's in charge of litigation like Elaine. A lot of the thing is looking for the relative strength of the cases and being like, here's something that I reckon is a 5% chance, and here's something that I reckon is a 0.001% chance, and which one am I going to take? But yeah, I'll hand that over to you, Elaine, and I'll drop that article in the chat as well. I think it's reasonably user-friendly.
Yeah, thanks, Tim. Yeah, I think with all of these things, we can't sort of give broad legal advice about who might have claims and who may not and how strong they might be. But I think, I do agree with Tim that those that have a direct financial or economic interest in places that are being harmed potentially have, an easier type of case to look at. But in all of those matters, you'd need to approach a lawyer and get some legal advice. I think one of the things with these sorts of test cases can be difficult when the plaintiff has concerns about the costs risks. So in Australia, if you take a case and you're unsuccessful, there's a high risk that you could be ordered to pay the legal costs of the other side, and that's sometimes a risk that prevents organisations like tourism operators from wanting to step into the litigation field.
And those costs, by the way, Elaine mentions, are not insignificant. Like there are organisations, environmental organisations, that have gone bankrupt over an adverse court cost. Which is why you see that a lot of the cases, particularly, there were multiple cases on my big slide that were ACF because really you need to, if you're an environmental organisation, often you want to be one of two things. You want to be an organisation that is entirely disposable, because if you get an adverse cost order, you may not exist anymore after it, or you want to be an organisation that is so big that it doesn't matter how big the adverse cost order is, you're going to survive. I want to pick up on one extra point on Elaine mentioned. One of the things in negligence law also that particularly a physical impact on someone is taken more seriously than an economic impact. Oftentimes it's easier to prove. So if you're going to be physically hurt, partly because the law was designed for person and person type stuff and physical injury stuff. And it was kind of an uncomfortable analogy when it first started being used for economic purposes. And now we're talking about doing another uncomfortable analogy again. It's more comfortable for that area of law for it to be reasoning from that physical injury thing. But unfortunately, it's really hard to prove ahead of time, particularly physical injuries related to climate change. It's hard to, we know heat wave is Australia's largest natural killer, but we don't know who's going to die, which is a bleak way of thinking about it, but it's the way that the law does sort of grapple with this particular issue.
And I guess to add to that too, where you're talking about focusing on physical harm, I guess air pollution is increasingly shown to be a major health risk. Enormous numbers of people, millions of people around the globe dying from that. And we've seen with our recent black summer bushfires also measurably coming out, so additional mortality associated with that air pollution from respiratory and cardiovascular events. Whether it's from those particular events or even locally from the burning of fossil fuels, whether it's in the Hunter Valley or whether it's in the Latrobe Valley in Victoria, what are the prospects, and are there any examples that you're aware of where those fossil fuel companies have been taken to court on health grounds, or is that something that is likely to start arising?
Well, there's no cases I'm aware of that have attempted that to sue a fossil fuel company for the health impacts of climate change at this stage. Again, very difficult kind of case to run, but
I think the closest would be the Hazelwood fire, wouldn't it, Elaine? Which wasn't a litigation per se, but it was a big inquiry with lawyers and litigious in a way.
Yes, yeah. And of course there are many cases where individuals have sued for actual harm and damage, but not on a climate basis as far as I'm aware.
Okay, an interesting question here, and I think you could extend this to all judges, and that is what proportion of our High Court judges, but possibly other levels as well, would have an understanding of the urgent nature of climate issues and, an understanding of climate science more broadly?
There are unfortunately, extraordinarily few judges in Australia who have a science background at all. Because obviously to be a judge, almost like the vast majority of judges are lawyers all the way down, have been lawyers their whole career. It's a very well understood problem for anybody who's dealing with an issue of scientific expertise, whether it's patent law, through to environmental law, through to any number of other areas, that a real shortcoming of our legal system is the lack of scientific literacy among judges. Which is why I think, Elaine particularly mentioned Will Steffen, who's one of my colleagues at the Climate Council, who's been involved in a lot of climate litigation, partly because he's relatively senior, which means there are no reputational risks with regard to this that he's going to care about, because he is at that point of his career and prominence where nothing people say about him can hurt him. And he's in a lot of these cases. So he was expert witness for the Rocky Hill litigation. He was expert witness today for the Sharma judgment. He is often trotted out for these things. One issue that's really an area where this really comes to the fore is a former colleague of mine. I probably shouldn't name him. I'm trying to think of whether I probably can. It's written up in a journal article, so I think he'll be okay with it, where he had his entire integrity attacked by the judge at the end of the day through his involvement in a piece of litigation where the judge said, "Oh, I'm sorry, you spoke beyond your expertise, therefore I'm going to disregard your evidence." The judge had no idea what his expertise was, because he didn't understand his expertise, because he didn't attempt to ask. And this particular topic was absolutely within his area of expertise, but the judge, who didn't understand the topic, decided it wasn't. And so this particular person, I won't name him, but this particular person has decided, no, I'm never going to be involved in climate litigation again. Like, this is ridiculous. Why would I put my professional reputation on the line for this? And it's a big problem, not just with climate, but more broadly with just scientific literacy of judges.
Thank you, Tim. I think Kylie's having a little bit of trouble with her computer, so I'm just going to step in to take her place until she manages to come back online. And we've probably got time for maybe 2 more questions at most, and I'll just fire one question to Elaine. You were talking about the Waratah case. A lot of us, many of those present, are not so familiar with the Waratah case and more familiar with the adjacent Adani mine. If the Waratah case is successful, what impact, if any, would that have on the Adani mine?
So that's a really good question, and we get asked that question a lot. The Adani mine obtained its environmental approval several years ago. So that particular case won't have a direct impact on the Adani mine, because the Adani mine already has the corresponding approval from the Queensland government. They've also got their federal approvals now as well. So yeah, we get asked that question a lot.
Okay. Just looking at trying to grab one more question before we wrap up. Look, one issue that has been very prominent, I know, in Victoria, and I imagine also in New South Wales, the problem of logging and cases against logging. You're probably aware that there's an interim judgment in Victoria to stop logging in some coops where wildlife was endangered. But it seems that I'm not sure if that has already been overturned or is likely to be overturned. But what do you think there's much future in instead of arguing the case for endangered species, to argue the case for the contribution of logging to climate change?
Yeah, I mean, that's another really great question. And I think these are all things that as environmental lawyers, we're sort of turning our mind to all the time as we look for the next case, the next big case to run. I think, you know, it's absolutely recognised that retaining our native forests is critical to addressing the climate crisis, that the two are inextricably linked, that you can't just focus on emissions from production of fossil fuels, and you've got to also look at the carbon sinks and retaining these really important carbon sinks in forests and wetlands. And so, yeah, I mean, that's something that at the EDO we think about all the time as we're looking at what the interplay is between our work on climate change, biodiversity and freshwater as well, which is sort of the third crisis, I suppose, that we're facing, is the water security crisis that is interlinked. All those three are interlinked, and we don't look at forestry and biodiversity without thinking about climate change and how climate change legal arguments can work together with protection of our forests. So, yeah, it's another one. Watch this space, I suppose. That's all I can say at this stage.
So just to wrap up then, thank you, Tim, and thank you, Elaine, for giving us your time this evening. I think you've really opened some horizons to many of us in understanding the contribution that the law can make to climate change, not something that many of us have been particularly aware of. Thank you very much for that. Before I close, I would just like to remind all of those present that BCAG conducts monthly meetings on alternate months. In other words, next month, June, it will be a face-to-face meeting. COVID restrictions permitting. I hope we're out of lockdown before then. So we are expecting to have, or planning to have, a face-to-face meeting at the Hyatt Community Centre last Thursday of June on the topic of waste and the circular economy. That will be co-sponsored or co-hosted by Bayside City Council, that will be helping us with that event and providing some really interesting insights into the way waste treatment is changing, not only in Bayside, but across metropolitan Melbourne. So thank you all and for coming. And I hope everyone has found tonight's webinar as interesting as I've found it. Thank you.
If I could just add one last thing as well on there. Thank you so much for having us. And if anyone's interested in exploring this one of the best books, and I should be on my shelf here, but I've obviously lent it to somebody. Roger Cox, who's the lawyer behind the those two Dutch cases that we mentioned, his book Revolution Justified is a really, really good book for digging in and learning a bit more about this. The first half of the book is general principles about climate law. The second half of the book is stuff that's unique to Dutch negligence that you don't need to care about. So you only need to read the first half, but it's well worth a read if you want to explore more. Thank you very much for having us.